There's night glam, shining bright, colors dance in the night. You don't owe them a thing, it's not up for debate.
Is that right?
It finally worked. That was so easy. I just put that mic together. I literally just screwed the bass on and plugged it in. That was the easiest thing. And they say that this is supposed to be like studio quality mic. So hopefully I will have no more sound issues because that was not good. Let's see. I'm so excited about this here though, because this is the order on defendant's motion in limine regarding Riley Nolan touch DNA and contact DNA. I'm so excited to read this one. It says defendant moves in limine to exclude the testimony of Riley Nolan, the lab manager with the Idaho State Police Forensic Services Laboratory, who was disclosed by the state to testify about touch DNA and the transfer of DNA generally, and more specifically, that DNA located on the knife sheath was more likely a result of direct transfer. Defendant argues that Ms. Nolan's testimony, as well as any other testimony referencing the terms touch or contact DNA and or purporting to be an opinion about the means or mechanisms of how DNA ended up on the knife, is relevant or impermissible under IRE 403 and fails to satisfy IRE 703. Oral argument on the motion was held April 9, 2025, after which the court took the matter under advisement. The court does not find exclusion of Ms. Nolan's opinion is warranted. However, the court requests that the parties instruct their witnesses to avoid the use of touch DNA, contact DNA, and trace DNA. So it's like, what do you call it? You call it transfer. You call it transfer DNA, like it's supposed to be called. And I know that like this is granted in part and like denied in part, but really I think this is a win not only for the defense, for Brian, but for the legal system. And anytime you're making an argument that goes against what's already going on in the legal system and going against public perception, that's an uphill battle. No one will ever win. So the only way you start those arguments is by laying a foundation. The defense laid the foundation beautifully here. Because if you can't use the terms touch DNA, contact DNA, or trace DNA, what do you call it? You call it transfer DNA. So that was great. That was great. Unless Becca Barlow has like something else that she wants to call this, I think they're going with the term transfer DNA like it always should have been, which is great. So further down, he says standards. The admissibility of expert opinion testimony is discretionary. State v. Almaraz. Likewise, whether to exclude evidence under IRE 403 is discretionary. On these discretionary matters, the trial court must, 1, correctly perceive the issue as one of discretion. 2, act within the boundaries of such discretion. Act consistently with legal standards applicable to specific choices before it. And 4, reach its decision by an exercise of reason. Facts. A knife sheath was recovered from the crime scene in this matter and swabbed for DNA. A sample of DNA identified as Q1.1 was extracted from the swab by the Idaho State Police Forensic Lab, ISP Lab. The DNA concentration was 0.68 mg-UL. And I think I have another video that says this is actually a concentration amount. We're still kind of unsure per volume, the actual amount of DNA. This is something different when they add the UL at the end, but anyway, we'll keep going. It was subsequently tested using standard DNA STR, short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. The state disclosed Riley Nolan, the lab manager for the ISP lab, to testify to the operations of a forensic laboratory, the structure of the ISP lab, and the types of evidence it possesses or processes. Per disclosure further states, Ms. Nolan will testify to touch DNA and transfer of DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it is deposited and transferred onto an item of evidence, the methods used to collect and preserve touch DNA samples from items of evidence, the procedures and protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from touch DNA samples are interpreted, and the reliability of touch DNA analysis and its acceptability in the field of forensic science. Nolan will also testify to the potential for DNA to transfer between an individual and an object, including the distinction between primary and secondary transfer, and the factors influencing the likelihood of transfer. The state's exhibit S-21, Nolan Initial Disclosure, on February 17, 2025, the state submitted its rebuttal disclosures, including one from Ms. Nolan. The focus of the second disclosure is touch contact DNA and direct versus indirect transfer, including factors that influence the transfer and persistence of DNA on an item. The final paragraph of her rebuttal disclosure states, many complicated factors can influence the likelihood of transferred DNA and the persistence of transferred DNA after disposition. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, i.e. direct or indirect transfer. It is possible the DNA detected on M2022-4843, item 1.1, resulted from secondary transfer. However, based on Nolan's training and experience, it is her opinion, given the quantity of DNA detected on item 1.1, and we've talked about this before, the 01.68 ng-UL, that's a concentration amount, not the actual volume amount. It's this UL here that indicates that that's not the actual, so they never corrected this. I have a video on that, we can go over that later, but this is still, we still don't know what the actual amount of either the total amount of DNA or the DNA recovered. Yeah, the total amount of the source or the total amount that was actually recovered. So, and then given the DNA profile obtained is a single source, it is more likely the result of direct transfer. That's exhibits S11. And the footnote here says, the state filed an amended supplemental disclosure of Ms. Nolan on March 3rd, 2025, exhibit S7, but it did not change the foregoing paragraph. Okay. Analysis. Defendant's argument is threefold. First, he seeks to exclude any testimony by Ms. Nolan regarding when and how the DNA found on the knife sheath was transferred there, arguing it conflicts with the current consensus within the forensic science community, is outside her expertise and is speculative. Second, he argues generally that use of the terms touch and contact DNA should be prohibited at trial as misleading, confusing, and unfairly prejudicial. Finally, he argues that Ms. Nolan's rebuttal opinions must be stricken as improper rebuttal. Each will address in turn. So, A, Ms. Nolan may offer disclosed testimony about DNA transfer if scientific, technical, or other specialized knowledge will assist in the trier of fact to understand the evidence or to determine a fact in issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. IRE 702, to determine whether expert testimony is admissible, the district court must consider two factors. State v. Calles Bautista. First, to give expert opinion testimony, a witness must be qualified as an expert on the matter at hand. Second, once the witness is qualified as an expert, the trial court must determine whether the expert's opinion testimony will assist the trier of fact in understanding the evidence. Expert opinion, which is speculative, conclusory, and unsubstantiated by facts in the record of no assistance to the jury in rendering its verdict and therefore is inadmissible as evidence. 1. Ms. Nolan is sufficiently qualified. Oh my gosh, double eyes! Thank you so much. That's my very first super chat. Oh, welcome. Thank you so much. So, whether a witness is sufficiently qualified as an expert is a matter of largely within the discretion of the trial court. In arguing Ms. Nolan is not qualified to render an opinion on DNA transfer, defendant contends that within the forensic community, there is a consensus that only experts specially trained in DNA transfer are qualified to render such opinion. He asserts that a lab analyst, Ms. Nolan, does not have the expertise to proffer an opinion in this case as how the DNA was transferred to the sheath. To establish this consensus, defendant relies on 2 forensic science publications regarding DNA transfer, both of which recommend that DNA analysts should avoid rendering opinions regarding DNA transfer absent specialized training. The first article, authored by 5 forensic scientists in 2019, discusses what we know about DNA transfer and the associated elements of DNA persistence, prevalence, and recovery, sometimes referred to as DNA TPPR. R. Van Oorschot, DNA Transfer in Forensic Science, a review, Forensic Science International, Genetics, Volume 38. Oh, there is a footnote. Number 2, defendant did not provide this article to the court. The court obtained a 19-page portion of the article from the web, including the abstract, which contained the quote relied upon by defendant. The web version does not reference the page numbers of the published article, i.e. page 140 through 166, but is page stamped at 1 through 19. Citations herein are to the web version. Wow, so he went to go find this. All right, good for you, Blair. All right, moving on back into the body of the document. The express purpose of the article is to assist casework investigations of criminal activities, and the information therein should be used where relevant. It further states, appropriately trained forensic practitioners are best placed to provide opinion and guidance on the interpretation of profiles at the activity level. However, those requested to provide expert opinion on DNA-related issues are often insufficiently trained to do so. We advocate recognition of DNA activity associated expertise to be distinct from expertise associated with the identification of individuals. This is to be supported by dedicated training, competency, testing, authorization, and regular fit for purpose proficiency testing. And that was a quote, but I think there's a footnote. So let's go down here to the footnote. It says, 3, by activity level, the authors mean generally accepted hierarchy of propositions for evaluation of evidence in forensic science, R. Van Oorschot. And I have several videos on propositions. So if you want to look through the most of my lives, we could go through that again because that's really important because it goes hand in hand with this subject right here. All right, so going back up to the body, it says notably the journal in which the article appears, Forensic Science International Genetics. It is an international one, and each of the 5 scientists are from outside the United States. The second article is a report published in May of 2024 by a group of individuals referred to as the Expert Working Group on Human Factors in Forensic DNA. And there's also a footnote here. And before I get to the footnote, we read this. We read this before Becca put it in her original motion eliminate. So we were all ahead of the game when we were reading that, which is also amazing. All right, down here at the footnote, it says, okay, available. He gives the link. He says, There were approximately 25 individuals in the expert working group, the EWG. We went over the EWG very early. I think it probably is like my third video. We went over that too. They included an international group of forensic science experts in DNA interpretation, academics in forensic science and law, statisticians, cognitive scientists, and representatives of professional organizations and standards developing organizations. Okay, so that footnote is denoted here right after he talks about the second article published in May of 2024 by a group of individuals known as the Expert Working Group on Human Factors in Forensic DNA. Melissa Taylor et al., Forensic DNA Interpretation and Human Factors, Improving the Practice Through a Systems Approach, NIST, and it was an internal report. The express purpose for the report, which was sponsored by the U.S. Department of Commerce, National Institute of Justice, Office of Investigative and Forensic Sciences, was to conduct a scientific assessment of the effects of human factors on forensic DNA interpretation with the goal or recommending strategies for improving the production, evaluation, and communication of DNA results. Section 7 of the report is dedicated to DNA transfer, specifically the how and when questions. And with regard to the expert testimony regarding the transfer of DNA, the report explains that except in ground truth known experiments where the individual is observed to have been in contact with the surface location, it is not possible to know whether transfer was direct or indirect. It further states that providing opinions about the probability or possibility of direct or indirect transfer is problematic, stating, I came back to check on you and deviled eyes. Thank you. So I'm interested to know, because I know that Hippler has assistants. I want to know if Hippler actually went to do this or if he worked with them. Like, I would be satisfied if he worked with them for them to kind of research some of this and like beef up this response. That would be acceptable and that would be cool, because the way he's written this, it does look like he looked into it. It does look like he took the time to actually kind of understand what's happening here. And I just don't know whether that's him or his assistants or if they, work together. Because this is written pretty well so far. Okay, and so now he's gonna further talk about that report, Human Factors, that we all read about. It further states providing opinions about the probability and possibility of direct or indirect transfer is problematic, stating evaluations considering factors such as transfer, persistence, and background require and evaluation of the biological results, giving propositions that address not the source of the DNA, but the activities that may have taken place. This in turn requires the use of data, knowledge, and expertise on DNA transfer, persistence, prevalence, and recovery, DNA-TPPR, rather than knowledge of DNA profile characteristics, probabilistic genotyping software, PGS, and population frequencies. In this regard, DNA-TPPR and assessments given activity level propositions are a separate scale, distinct from standard DNA profiling and interpretation. It may be a function limited to only a portion of DNA analysts with the required expertise. At present, there are not adequate educational opportunities to inform these types of issues within the United States. The report goes on to note that an expert rarely, if ever, has all the information needed to perform a robust, balanced, and transparent evaluation of biological results regarding transfer and specific activities on the witness stand. Consequently, the report advanced the following recommendation, and we are familiar with these recommendations because we went over them, and Bicca also included them in her motion in limines. So this is the following recommendation. Recommendation 7.1, DNA analysts should not opine about the possibility or probability of direct or indirect transfer having occurred in a case. Based on these two articles, defendant posits that Ms. Nolan, as a typical lab analyst, is not qualified to substitute her judgment in the face of the weight of the forensic community's agreement with the science and literature does not support any analyst testifying about when and how of transfer. State responds that defendant's argument is both legally and factually flawed. The legal flaw is that it misapprehends the appropriate standard to determine admissibility of an expert opinion. The state asserts that the standard is not the consensus of the scientific community, but on whether her knowledge will assist the trier of fact. The factual flaw is defendant's failure to mention the lack of consensus in the EWG working, the EWG expert working group regarding recommendation 7.1, footnote 455. The article notes that 2 EWG members dissented from the recommendation, stating, while the dissenters acknowledge the analysts are often asked to respond to how and when questions in criminal cases and agree that testimony on this subject can be misleading or otherwise problematic. Let me read that again, because apparently nobody's paying attention to that. The dissenters say that testimony on the how and the when can be misleading and otherwise problematic. They believe that broad prohibition in recommendation 7.1 puts the proverbial cart before the horse by not first requiring these assessment of type outline in the recommendation 7.3. All right, so what is 7.3? There's a okay, so then he just goes on to say what 7.3 point. Okay, so it says, puts the proverbial cart before the horse by first requiring an assessment of the type outlined in recommendation 7.3. Moreover, they worry that supporting 7.1 would imply the need for analysts to shift to a new paradigm that has not yet been sufficiently vetted within the specific context of the U.S. court system. All right, so we talked about this in another live. These dissenters, they don't dissent that it can be misleading when you are asked about how and the when of the DNA. However, they want 7.3 to be first, and they're very aware of a new paradigm that has not yet been sufficiently vetted. And it will be vetted. This is just huge. None of us have ever seen our legal system work in this way before. And I don't even think we can imagine how it's going to work after this comes through. And I think what they're talking about here is something administrative. It's something like strategic management. It's not, I think it's just going to sweep through with like procedures and policies. And I hope what that does is it actually takes labs and DNA and analysts out of law enforcement, that it makes them independent so that they are not, they're not there for the confirmation bias. They're not like actually working for the police to like force a result. Oh, we have onward and outward. Hello. Onward and outward says, I hope he helped and really has a grasp of what it really is. And you bring up a great point. I was saying before, I don't know how much that his assistant wrote this, but if they work together, that would be good as well. It does sound like he has an understanding of this. And this is another one of those things where you have to kind of read between the lines a little bit. Oh, hello. And we'll get to that. I'll talk about what the in between the lines are, because even though this is partially granted and partially denied, I think it's still a win for the defense, but I don't think anyone else is going to feel that way. Well, I'm optimistic anyway, but still, I think this is huge. Okay, so then we just read that. And again, the dissenters, they don't necessarily disagree that providing testimony on the how and the when can be problematic. They just think 7.3 should be first, and they do worry about a new paradigm. And let me tell you, it'll be a big change. So here's 7.3. This is the one they want to be first. Recommendation 7.3 acknowledges the lack of DNA TPPR educational opportunities within the United States and recommends that the federal government to review the foundations and principles of evaluating biological results when considering alleged activities, and depending on the findings, makes funds available to educate and guide DNA and legal communities to review research, selection, and validation of appropriate methods to account for DNA TPPR when assessing biological results. And I think that's fair, and that will come. That'll come along with the new policies and procedures that will follow along with this. And that was very fair of the dissenters to say. And I don't think that the dissenters, I keep calling them the dissenters because I think that's kind of funny, but I don't think they're dissenting in the way that the prosecution is trying to make it sound like. Which I think does get lost a little bit in here, in this, but besides that, I still think this was written pretty well. Besides, they still lost. Anyway, we're going back up into the body. We had just finished reading the footnote. The court finds Ms. Nolan to be sufficiently qualified to render her opinion on DNA transfer, despite her lack of specialization in DNA TPPR. The test for determining whether a witness is qualified as an expert under IRE 702 is not rigid. A qualified expert is one who possesses knowledge, skill, experience, training, or education. This language is intended to provide wide latitude in how a witness may qualify as an expert. In situations where a witness has general expertise in a broad subject but is not a specialist in the specific aspect of that subject that is pertinent in the case. Most courts conclude that the general knowledge can be sufficient to qualify the witness as an expert. This is because the issue under Rule 702 is simply whether the testimony of a witness with only a general background is reasonably likely to help the trier of fact, not whether a specialist would be preferable. Differences in expertise bear chiefly in the weight to assigned the testimony by the trier of fact, not its admissibility. According to her affidavit, Ms. Nolan is currently qualified and proficiency tested as a DNA analyst and has so qualified for 20 years. And that was from her affidavit. Okay, there was a footnote that I missed here. It says number 6, given IRE 702, it is substantially similar to its federal counterpart. Federal authorities interpreting FRE 702 are instructive. Okay. All right, so then in Ms. Nolan's affidavit, she says she worked as a forensic scientist in biology/DNA at the Idaho State Police Forensic Services Lab for 11 years before becoming its manager. She is certified by the American Board of Criminalistics and is a molecular biology fellow. She is a member of 4 professional organizations in the forensic field. She has taught courses to law enforcement and medical personnel on DNA in forensics context and has published scholarly journals on the subject. Oh dear. Oh gosh. She should stop publishing. Anyway, based on her professional experience in forensic DNA field, Ms. Nolan, at the very least, possesses the general expertise to opine on matter of DNA transfer. Given her general expertise and lack of specialized DNA TPPR training as advocated by the defendant's authorities goes to the weight for testimony, not its admissibility. Further, in challenging her qualifications, defendant is seeking to hold Ms. Nolan to an aspirational standard of expertise in the forensic field that is to, for now, that's key. Let me finish reading the statement and we're going to get back to that. And that's kind of clever that he put that in there. Oh, wow. Okay. Defendant is seeking to hold Ms. Nolan to an aspirational standard of expertise in the forensic field that is, for now, is nothing more than a recommendation, and a disputed one at that, within a segment of the forensic science community. There's a footnote. Defendant has not established a scientific consensus in the United States outside of the EWG, which comprised of only 25 individuals, only some of which are forensic scientists. All right, back up into the body. Not only do defendant's articles fail to establish any established standard of qualification, Ms. Nolan disputes that there is a consensus in the forensic DNA community that a lab analyst should not opine as DNA TPPR. She points out that not only where the dissenters to the EWG working group, recommendation 7.1, there is a divide in for forensic DNA community on this topic. Now, he puts in here for now. This is Hitler or his assistant. I wonder if he picked up on a lot of the things that we picked up on when we were reading that these are recommendations now. This is coming from an administrative angle, and these will be implemented. Like the report we read was different from anything else. What's going to happen to the legal system is different than anything that's ever happened to it. And I do think it's going to take some of the power away from law enforcement and the court, which is exactly what we need, because we need a neutral third party that has these types of standards to be able to, be responsible with this type of thing, because we already know of all those stories about those DNA experts who were, fudging the results for like 30 or 40 years. Like, that's insane. So what we have here is something on a humanity level. There are intrinsic laws that one has that is above any court. I do believe that the fundamental of these types of recommendations is actually based on that. So when you have something that's based on like a humanity level that is above the jurisdiction of the court, you're right. It'll be a recommendation for now. And then it will actually create a new paradigm, which we don't know what that's going to look like. And it's also awesome that he put that in there because, like I said, whenever you are arguing against what's actually going on in the legal system, you're arguing against public knowledge or what they think DNA is, that's an uphill battle. Nobody is going to really win those arguments. So what you do, you lay a foundation. So in the future, if anything else changes, they have this already written for them. And that would help an appeal if they get there. So next, Ms. Nolan disputes this consensus. And so Ms. Nolan explains, one side supports the EWG recommendation. The other side believes that not offering an opinion based on knowledge of molecular biology / DNA when it may aid the trier of fact is unethical. At the most recent American Academy of Forensic Sciences meeting held in Baltimore in February 2025, there were presentations supporting both sides of the argument, demonstrating the current divide in the community. And we read that. And there was not. Within the program that is available free online, there aren't any workshops where there are people who disagree with that. All of the workshops are targeted for those not targeted. They're there to train everyone because this is the direction. This is the direction, the new paradigm. We are just ahead of it. We just know of it beforehand. So I don't know where she's getting that from. Because if you look at, which we did, not true. More importantly, Idaho has not adopted the standard for admissibility set forth in Daubert, which considers whether the expert's theory is commonly agreed upon or generally accepted. Noting that the expert opinion need not be based on information that is commonly agreed upon, or universally accepted. Therefore, whether is there a general consensus supporting Ms. Nolan's opinion or not is a relevant ability. Okay. Nolan, absent either party's briefing or court cases discussing the issue of whether DNA analysts are qualified to testify to DNA transfer, a review of case law reveals that such opinions are offered by DNA experts without dispute over qualifications. Okay, number 8, there's a footnote. I'm going down here. DNA analysts testified that a lower level of DNA should be found through secondary transfer, and that considering the high concentration of the defendant's DNA found on the victim's right breast, we're not talking about Brian v. Koberger. This is from another case that they're referencing to support their argument with. So a high concentration of the defendant's DNA found on the victim's right breast. It was highly unlikely that the right breast swab would have contained transferred DNA. That writ was denied. Forensic scientists from the regional laboratory testified that defendant was a major contributor to DNA found on shell casings and upon the defendant's DNA was present through primary transfer. 2 things with that. There has been an evolution of DNA since then, and so now that the scientific community and scientists, they're figuring out that regardless of the amount of DNA, you still can't really tell if it's primary or secondary, direct or indirect transfer, because somebody who isn't a shedder wouldn't shed their DNA, and then the next person who touches or is around that person, they are a shedder. So then it looks like that person is actually the direct the primary contributor, when in reality it wasn't. It was just because the first person whose DNA is absent or is less because of the way, our biological bodies shed stuff. We're all different. And so what science likes to do is they like to put things in these like equal measurable boxes. So it's like, okay, well, if there's more DNA, that means somebody touched it. Maybe that makes logical sense, but not when it comes to it with our bodies and the way that we like shed our biological material, because everybody is different. So they're figuring out that this trace transfer DNA, you can't say conclusively who touched it first because of the way our bodies work. There's just nothing around there. All right. And then so that conclusion, I don't know if they knew it was flawed when they were writing that, but they still don't. Anyway, so now we're going back up into the body, not up here. It appears only one court, a military court, has squarely addressed the issue and declined to find the DNA analyst was unqualified to render testimony. When was that? We might have to look up this court case, 'cause I didn't think military court used trace transfer DNA. But that also shows that somebody did their homework when they were researching stuff, unless this was quoted in one of the articles that was given to him, to Hibbler. In doing so, the court rejected the notion that DNA transference was a separate science from DNA extraction and analysis, and therefore the expert in DNA was qualified to testify to transfer. There's footnote number 9. While military courts are governed by separate evidentiary rules, the rule governing expert testimony, MRE 702, is the same as FRE 702 and subsequently similar to IRE 702. That's a little dicey because, all right, so say the military court is talking about regular DNA and transfer and stuff, like blood splatter transfer. That's a lot different. I'm curious. That's a lot different than the trace transfer. I'm gonna look it up real quick. Let's see. What was it? Was it trace transfer DNA? I don't know, that might take too long. It didn't give me answer right away. So we'll go back, we'll look at that later. It says, in sum, given the liberal standard of qualifying as a witness, Ms. Nolan's experience and training in the area of forensic analysis of DNA generally, the current divide in the forensic community regarding whether lab analysts are qualified to testify to DNA transfer, and the lack of jurisprudence on the matter, the court declines to find that Ms. Nolan lacks the qualifications necessary to provide an opinion on DNA transfer in this case. Defendant's challenges to her qualifications affect simply the weight to be afforded to her testimony. 2. Ms. Nolan's testimony will assist the trier of fact. Having determined Ms. Nolan is qualified as an expert, the court must determine whether her testimony will assist the trier of fact in understanding the evidence. This condition goes primarily to relevance. One aspect of relevancy is whether the proffered expert testimony is sufficiently tied to the facts of the case such that the testimony will aid the jury in resolving a factual dispute. An expert's opinion that is speculative or unsubstantiated by facts in the record is inadmissible because it would not assist the trier of fact. If the expert testimony is competent and relevant, it may be admissible. The weight given to the testimony is left to the trier of fact. Okay. Defendant argues Ms. Nolan's rebuttal opinion that the DNA detected on Q1.1 is more likely the result of a direct transfer is speculative because it offers possibilities that are not based on substantive scientific principles. The state responds that Ms. Nolan's rebuttal disclosure sufficiently explains the scientific principles underpinning her opinion and the reasons for her opinion. In addition, the fact that Ms. Nolan cannot testify conclusively as to when and how the DNA arrived on the knife sheath does not, according to the state, render her opinion speculative or otherwise unhelpful to the jury. This court finds Ms. Nolan has identified an adequate scientific basis for her opinion. Her rebuttal disclosure reveals that she will discuss the difference between single-source DNA profiles and mixtures, concepts pertaining to direct and secondary transfers of DNA. The variables can influence the transfer, persistence, and recovery of DNA. 10, let's go down, there's a footnote. The variables cited in Ms. Nolan's rebuttal disclosure include whether the DNA profile was single source or mixed, whether the transfer was through body fluid, the depositor's biological factors, shutter status, here we go, shutter status, personal hygiene, and rate of perspiration. That's right there. That's why it's very difficult in science and for lab analysts to determine if it was direct or indirect, because there could be another person in the mix that has a lesser shutter status, maybe a little better hygiene, and maybe their rate of perspiration isn't as frequent. And you wouldn't see that person's DNA, or they might look like a minor in the mixture, because you have a minor and you have a major. That's the the juxtaposition of these profiles that you can see within a mixture. Some are bound to be larger than others. Okay. All right, we're going back up into the body now. It says, in fact, this discussion closely mirrors the TPPR DNA principles advocated in the articles cited by the defendant. While defendant may not think Ms. Nolan is adequately qualified to offer an opinion on DNA TPPR, that does not render her opinion devoid of scientific principles. In addition, although Nolan admittedly cannot testify conclusively as to whether the DNA was transferred to the sheath by direct contact rather than indirect contact, this does not render her opinion speculative. Testimony is speculative when it theorizes about a matter as to which evidence is not sufficient for certain knowledge. An opinion that is speculative suggests only possibilities that may be properly excluded, since the opinion would not assist the trier of fact. Ms. Nolan's opinion does more than suggest possibilities. She states that while it is possible the DNA on the knife sheath was from secondary transfer, it was more likely the result of direct transfer, given that 1, the DNA was a single source profile, 2, there was 0.0168 mg of DNA detected on the sheath, period. Now, I don't know if this is a typo, but it doesn't have that /UL at the end. I asked ChatGPT 0.0168 mg if that was an appropriate amount for direct transfer. And it said no, that this is actually on the lower end. If this is, which we don't know, if this is the actual volume of the DNA, the actual amount of it from the source or from how much was recovered, not the actual solution that it was in, for them to determine, to calculate how they calculate that. So I'm still interested to know what the actual amount is. I just noticed here that every time we've seen this amount, it's had the /UG on it, and it's the first time I'm seeing it where it's not there. So I'll read that again. Number 2, there was a 0.0168 mg of DNA detected on the sheath. As the state points out, an expert may testify to a likely opinion, particularly where the expert acknowledges the limitations of such opinion. In State v. Hall, for example, the forensic pathologist testified that, based on the lividity patterns observed on the victim's body, he believed the victim was most likely hogtied after her death. In finding the opinion properly supported, the Idaho Supreme Court found this testimony was not based upon mere speculation or possibilities, but it was based upon the lividity patterns. In addition, the court noted that the expert admitted the limitations of his opinion. Ms. Nolan's opinion is no different. She will testify that, based on scientific principles regarding DNA transfer and her observations of the quantity of DNA and type of profile found on the knife sheath, it was more likely a direct transfer rather than secondary transfer. Further, the fact that she admittedly cannot render a conclusive opinion about how the DNA arrived on the knife sheath, and that it is possible it was through secondary transfer, does not render her opinion admissible. It's simply an acknowledged limit to her opinion. Neither party has cited the case law discussing the admissibility of expert opinions on DNA transfer. However, the cases reviewed by the court indicate that Ms. Nolan's opinion is acceptable despite her inability to reach a definitive conclusion. In United States v. Perez, the government's DNA expert testified about the DNA transfer with regard to a mixed DNA profile found on a gun, 85% of which was attributable to the defendant. He discussed the differences between direct and secondary DNA transfer and variables that can affect the DNA transfer. He further testified that the amount of DNA found on a secondary transfer when compared to a direct transfer is expectingly less, specifically stating, I haven't seen an example where the primary toucher has less DNA than the secondary person. And typically the initial touching is going to give more DNA. He did testify that it was possible, but in general would think that direct touching is going to transfer more of the individual's DNA. Based on this testimony and the fact that 85% of the DNA was attributable to the defendant, the court concluded that a jury could reasonably infer that the defendant's DNA was deposited by direct transfer. Now, on a side note, if the experts are getting it wrong, which I do believe they may or may not have been getting it wrong there, but of course the jury is going to get it wrong. Because we now know that not in all cases, somebody could have a bigger mixture on a trace transfer, or even if it's single source, they could be the majority of the DNA found there, but that doesn't mean they're the primary contributor. There are so many factors that go into it that right now, the scientific community is advising against opining on the how and the when because of the new advances that we have in science, and now that we're realizing that just because there's more DNA there doesn't mean that it was actually touched first or primary or whatever. All right. In State versus Glass, the court found, based on the lack of expert testimony regarding DNA transfer, there was sufficient evidence to uphold his conviction. In that case, DNA was recovered from a latex glove at the scene of the crime. Analysts revealed a mixed profile, the results of which consist of the defendant from being the major DNA profile. The expert stated she could not, however, determine from her testing whether the transfer was primary versus secondary. The court found the fact that the defendant was a major contributor was alone not sufficient to establish the defendant's identity as the perpetrator. That's right. Just because there's more DNA on something doesn't mean somebody is automatically, the person responsible. And they're finding this out all over the world, and that's why they want to have global standardization when it comes to this trace transfer stuff, because it's more of a humanity thing. It's not like, okay, it's not coming from a law enforcement or scientific thing. It's convicting innocent people because we didn't quite understand DNA when they were convicted. But I like how, whatever case this is, State versus Glass, it said, the court found the fact that the defendant was a major contributor was alone not sufficient to establish the defendant's identity as a perpetrator. That's really important. I wish I had like a star or something I could put here so I could come back to that. Okay, it noted DNA experts testifying in both the United States District Court of the District of Connecticut and courts in other jurisdictions, however, have offered the evidentiary basis lacking in the present case. That is, the correlation between the amount of DNA deposited on the item and the likelihood that such DNA was deposited via primary transfer as opposed to secondary transfer. Misty! Oh, it's so good to see you. Hello, gorgeous. Aww. Misty Blue. So, and I keep giving you that quote. I need to find out who said it. I read it in one of these scientific journals that, it's no longer your DNA was found at the crime scene, so you probably did it. Like, that's such old science now. It's So even if there is this likelihood of primary and transfer, primary or secondary transfer, it doesn't quite go now. Anyway, we'll keep going. Among the cases cited by Glass Court was Perez-Subra. As concluded in Perez, the Glass Court found that the testimony correlating the amount of DNA on an item with the likelihood that it was transferred via direct or indirect transfer can provide a jury with evidentiary basis from which it is reasonably can infer that a defendant having been designated as a major contributor to the mixture of DNA makes it more likely that the defendant's DNA was deposited via primary transfer. The cases demonstrate that it is not outside the permissible bounds of an expert to opine as to the likelihood of DNA transfer. In fact, such opinion can be crucial to putting the DNA evidence into context. Yes, indeed, Ms. Nolan is offering the very opinion that Glass Court found. Now, I think what we're missing here is connecting evidence. If they had videotape of the car, it sounds like, they have videotape of the car, but then the state is trying to say it was going one direction when it really wasn't, because, the cell phone data shows it going a different direction away from Moscow. But that would be an example, or DNA in other places around the crime scene. That would link someone to a crime scene. You need something else that links that person to a crime scene. Then, okay. Then I think these likelihoods that it's more likely direct transfer, secondary transfer, yes, that would hold more weight. But since there is nothing else, there's nothing, this is exactly what the scientific community is advising against that you don't do. It would be different. Riley Nolan might be correct if there was other evidence here. But this is the very thing that the scientific community is like, if there isn't linking evidence, especially with this trace transfer, we don't want to contribute to these wrongful convictions because it is ambiguous. We don't know whether it's primary or secondary transfer. It's hard to tell. And especially in the circumstances where there isn't any other linking evidence. The only thing in this case is this DNA. And this is what the scientific community says you shouldn't have a case surrounding with. You shouldn't have just that. So I understand how he's arguing this and how Riley Nolan is arguing this, but that is only appropriate when there's linking evidence. There isn't any here. And so all of this is not appropriate argument. Anyway, I'll move on. Okay. These cases demonstrate that it is not outside the permissible bounds of expert testimony to opine as to the likelihood of DNA transfer, and in fact, such opinion can be crucial to putting the DNA evidence into context. That's it right there. Put the DNA evidence into context. And when there is nothing else in the case, there's your context. It doesn't belong. Indeed, Ms. Nolan is offering the very opinion that Glass Court found lacking. The correlation between the amount of DNA deposited and the likelihood it was transferred by direct or indirect contact. This will aid the jury in understanding the evidence. Consequently, her opinions will not be excluded. Misleading DNA levels are to be avoided. Defendant next argues that the term touch or contact DNA should be excluded under IDAHO4 because it could be misleading to a jury into inferring that the depositor of the DNA actually touched the object on which it was found. The state only addresses the term touch DNA and argues it should be allowed because it is a common term within the field. Side note, it's only a common thing because we didn't know what we knew before. And now that we know before, we don't want to put innocent lives in jail anymore. Like, I'm telling you, this is on a humanity level. It's not It's not on law enforcement on the legal side. Further, the state points out that it would be clear to the jury from Ms. Nolan's testimony that touch DNA is a term used only to distinguish the type of DNA from other kinds of DNA. 12, there's footnote, I'm going down. Footnote 12, Ms. Nolan's disclosure states she will discuss the characteristics and nature of touch DNA. All right, going back up to the body, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of the unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needlessly presentation of the cumulative evidence. Where? Cumulative evidence. I mean, I could usually sit here and say there isn't. The state should know better, but they're really stretching this other evidence that they say that they have. The pictures of the cars, they don't look like anything. And how do we know the car is actually related to the crime? The timeline is based on somebody who was under the influence, heavily under the influence of alcohol or text messages. Usually that is not scientific. And like I was saying before on the live before this one, I don't know if the medical examiners can tell the interval, post-mortem interval from the time the deceased person died to when they were found, which is a little bit different than time of death. Sometimes they're used interchangeably, but I guess sometimes you can differentiate between a few hours and sometimes you can't. So I am very interested to see, what does the medical information say about this post-mortem interval or time of death? Does that sway the timeline either way? Because once you wedge stuff into this timeline, that car may become less relevant. And when it becomes less relevant, you don't have a car, you don't have a timeline, you don't have cumulative evidence. You have this trace transfer DNA in a context where the scientific community is strongly advising against because of cases like this. So this cumulative evidence, we'll see about that. Moving on. The issue here is whether the word touch is prejudicial, as it implies that the DNA was transferred via touch. Touch DNA is a shorthand reference to the epithelial or skin cells that may be left behind on an object when it is touched or comes in contact with the skin. That is another thing right there. It doesn't have to travel by skin. And I was reading earlier because I wanted one of these lives to be about, what is a jury instruction? What should go into those jury instructions in case this word touch DNA does come out by the state or the defense, where jury instruction has to be where they will click. Because at the end of this document, I think Hippler says again, and he said it, during the hearing too, he wants both of the parties, the prosecution and the defense, to come up with, I guess, a term to use and, a jury instruction if just in case one of these words pops out. And so when I was looking those up, there are a few other cases that do have jury instructions about touch DNA, which is awesome. It helps support this argument where, Bicca and Massa, they're trying to lay the foundation for this argument. And one of those, there was a detective, in the jury instruction, it was because I think the detective said there was skin-to-skin contact, and that was touch DNA. I think that is extremely misleading because trace transfer DNA moves, it transfers, and it doesn't have to actually be skin-to-skin. It could be fabric. to fabric, fabric to skin, skin to fabric, fabric from body to fabric from skin. So it's not necessarily skin to skin. So we'll keep reading here. Back to it. Okay, touch DNA is shorthand reference to the epithelial or skin cells that may be left behind on an object when it is touched or comes into contact with skin. And that is from Can't Touch This. You can't touch this. Oh God, I think we have to play a song. We have to play a song. You can't touch this. Okay. Making a place for touch DNA in post-conviction DNA testing statutes. And that was the title of where I guess they got that little bit of information about contact with skin. It is sometimes referenced to as trace DNA. State v. Phillips. Affidavit of Nolan, indeed, scientific and legal literature as well as case law is replete with references to touch DNA. The two articles relied upon by defendant. Ooh, we got a footnote, number 13. Wait, footnote says, at least one well-known treatise on evidence has an entire section dedicated to touch DNA. Jones on evidence. McGiboney v. State, discussing the advent of touch DNA testing in Idaho. Interesting. I would like to read that. All right, back up to the body of the document. In fact, defendant's own expert, Dr. Ruth Ballard, references touch DNA in her report. However, as one of defendant's articles observes, the term touch can be misleading, as it implies one specific mode of action, and to some degree also a type of biological source. There it is. That is, side note, that is, wow. That's very specific. I also want to ask you guys, how should they do this jury instruction? Because the ones that I read are definitely inadequate. They're no, we got to make it sound good, you know, like something that the jury can like hold on to. Because I was thinking, like, I'm on the jury. There's bound to be some people who already know about touch DNA or trace transfer DNA. There's going to be others on there that no matter what you do, they're just not going to get it. They're just going to say DNA is DNA, whatever. But someone like me, if I didn't know about touch transfer DNA, I would be kind of excited, you know, that, oh, I learned something new. And I would be like, well, you know, with the new information that, you know, we were given by the court, I really feel like we should take that into consideration. And, you know, they said that touch DNA doesn't actually mean anybody touched anything. So we don't know if it was direct or indirect. So I do think there will be hopefully someone on that jury who will be thankful that they are given information that directly influences the case. You know, I don't know if some of you out there, if you get information like that, if you're appreciative. I've always been like that, like, oh, I didn't know that. Oh, that sounds, wow, okay, you know. Anyway, so we're going to talk about what kind of things, how should it be worded so it just sounds normal and not like so scientific. Okay. But I'll even that again, because even though these things are not really like, you know, layperson friendly, it does, it sparses it. It breaks these two things down in a very good way. And it also lets you know there are a lot of things happening in that loaded word, touch DNA. So here, one, okay, the term touch DNA can be misleading. For one, it implies a specific mode of action to some degree. Two, of biological source. How convenient has it been for prosecutions all over the United States to be able to use that term, touch DNA, to their benefit within two words. They've been able to suggest a biological substance and direct contact. And it really does tell a story. If you're talking about touch DNA, you're implying the defendant actually touched a key piece of evidence. And, I do think that that is unfair because how long has the state been able to get away with this? And I was telling everybody before, it takes brave defense attorneys to ask questions, to start arguing against this. And we've gotten to this point where Becca and myself are able to argue this because of some previous, brave defense attorneys. And it's also that makes a big difference are the judges who ask questions. I'll reserve what I'm thinking about this judge until the end. But this is a step in the process that will be happening. This is a huge step, though. This is I think, a win, considering not just the Kober case, but considering the scientific consensus and considering the new paradigm that's going to come through. And also, if it does have to go into appeal, I don't know when that's going to be, but if there is other law that's laid down, this document right here, written just by Judge Hippler, will aid in that actually, and I think it will go to Brian's benefit. But we'll talk more about that. So again, touch can be misleading because one, it implies a mode of action to some degree, and two, a type of biological source. That's dangerous when that term can have that much power. Instead, the authors suggest using the term trace DNA, which is less descriptive. Nolan, however, disagrees that trace DNA is a better term, stating, the term trace DNA implies amount. I don't, from my understanding, and I could be wrong, trace DNA is any type of DNA that you can't tell what it is, that you can't see, whether that's under your microscope, you can't see if it's blood, sweat, semen, or saliva. So when you are looking at, a very powerful microscope, you can't really tell which one of these bodily fluids it is. And I would also like to know if they can tell, because sometimes it's bodily fluids and other times it's skin. Can you tell the difference between that under a high-powered microscope? Because if you can't tell the difference between the sludge, the other types of bodily fluid versus skin, then yeah, I think it's appropriately named trace DNA because it's traces of biological fluid. You can't tell what it is. Or because if you could tell what it is, you would say, oh, that's blood DNA. Oh, well, that's semen. Oh, well, that's saliva. You would be able to say which one it is. But in these cases, you can't tell even looking under a microscope. Anyway, we'll keep going here. The term trace DNA implies amount. The word trace is defined as a very small amount and is used in the scientific literature when describing evidence samples with low amounts of DNA that do not yield a profile or only a partial profile. I would not be willing to use the term, and it would be inappropriate to apply that term to the DNA on the knife sheath because a trace amount is not what I detected on item 1.1, and referring to it as trace DNA would be misleading to the trier of fact. Well, Becca Byler is going to challenge you on that. Yep. Because I guess the state is just not going to clear up how much DNA they actually have. They confused it with the concentration amount. All right, further, given the ubiquitousness of the term touch DNA, in not only the forensic DNA field, but in the legal and scientific field as well, the court is unwilling to prohibit the term. Oh, we missed, did we miss footnote 13? No, we didn't. All right. There is too great a risk that a witness or counsel will inadvertently refer to the term out of habit, potentially giving rise to a motion for a mistrial for violation of court order. Moreover, the court is not concerned with the jury will be misled given both parties have DNA experts who can easily disabuse the jury of any mistake in correlating touch DNA that with actual touching. That is awesome. Correlate touch DNA with actual touching. Whoever wrote this, they're getting it. Wow. And it says this court correlating touch DNA with actual touching. Interesting. That said, the court asks that counsel avoid the use of the terms. Number 14, run to a footnote. Number 14 says, this limitation includes the terms touch DNA and contact DNA as requested in the motion. In addition, based on Ms. Nolan's concern over the term trace DNA, the court will advise against its use as well. All right, I was like, what are you gonna call it? I know what you're gonna call it. You're gonna call it transfer. You're gonna call it transfer DNA. Like it's supposed to be called. All right, anyway. Where were we before we got there? Okay. That said, the court asked counsel avoid the use of the terms as much as possible so that any potential confusion can be bypassed. To this end, the parties are instructed to submit a mutually agreeable instruction to provide the jury in case the terms are inadvertently used. Brilliant, brilliant, brilliant. So not only does the state and the defense have to come up with a term, I'm pretty sure they're going to come up with the term transfer. And if anybody utters the words touch DNA, contact DNA, trace DNA, there will be a jury instruction given. And we should all think about how that should be worded. We need to word it kind of normal, right? So the jury can like understand no actual touching has to occur. Maybe that should be in there. No touching has to occur. So you don't know. Awesome. So this is the homework the defense and state have to do. They have to agree on the terms that they will use. And as a backup, they will have prepared a jury instruction in case anybody slips. If nobody slips, the jury instruction doesn't have to be used. That's my understanding of it. I could be wrong. But that is awesome. And hours of that's the end. That's great. So giving them homework. Okay. If a witness uses the term, opposing counsel can examine the witness about the broader meaning of the term within the forensic community, and the instruction may be given at that time. Maybe maybe somebody should slip so that you get the floor. You just wipe the floor with all of what is going on in the scientific community now. Well, it's like you better be on your best behavior, or it's probably going to benefit the defense. All right. C. Nolan's rebuttal opinions are proper. Defendant's final argument is that Nolan's anticipated rebuttal testimony is improper because it does not respond to any opinion by defense-owned expert regarding DNA transfer. Oh. Okay, I just understood something. I was asking people on Twitter earlier today because when we get down there, it says like just like you know that move that they pulled where they're like, well, we're not going to have our IgG experts testify, so there's no need for Middleton to testify. You know, they kind of the defense pulled the rug from under the prosecution to be able to talk about where the tip came from. And I'm curious to see if this is another one of those possible events with different outcomes, of course. But anyway, Defendant's final argument is that Nolan's anticipated rebuttal testimony is improper because it does not respond to any opinion by defendant's own expert regarding DNA transfer. The court does not agree. Rebuttal evidence is evidence that explains, repels, counteracts, or disputes evidence which has been introduced by or on behalf of the adverse party. As the state notes, defendant's DNA expert, Ruth Ballard, acknowledges there is good support that Mr. Koberger's DNA was found on item 1.1, a swab from the knife sheath. However, her report indicates she will inform the jury that DNA on an item could be the result of indirect transfer from skin cell DNA. The disclosure implies the jury should give little weight to the defendant's DNA at a crime scene because it should just mean the defendant's DNA was nothing more than an innocuously shed skin cell DNA. Prior to the crime, and the knife sheath could be picked up and transported to a crime scene by someone else who sheds no DNA onto it. Side note, that is a fact. However, with the current understanding, I think with lay people and some of these juries, that it's very difficult for them to kind of absorb that and let that information sink in to understand it for what it is. I'll repeat that again because we know this now in science, but I don't, it takes forever for law enforcement and the legal system to, adapt principles. This will become a standard principle. I don't think it's quite here yet. So it says here, the disclosure implies the jury should give little weight to the defendant's DNA at a crime scene because it could mean the defendant's DNA was nothing more than innocuously shed skin cells DNA prior to the crime. And the knife sheath could be picked up and transported to a crime scene by someone else who sheds no DNA on it. And I think I've said that a few times, that somebody could be the primary transferor. That's the first time I've heard that word in this paper here. But they don't shed any DNA, so you would never know that that person was actually primary, or that was the person who was actually holding the object during the time in question. It depends if a person is a shudder or not, or their rate of shudder. And in lab conditions, that can be determined if that's the purpose of the study. But in real world conditions, I don't know if that's actually measured. I don't think people are lined up and a scientist walks by and tries to evaluate you for how you shed. No, that doesn't happen. Not in real world settings. So, and this is another thing where, science tries to, square everything into areas where the body is a little bit messier. So it doesn't always necessarily mean whoever has the most DNA in an object, that's the one who touched it. No, that I feel like that's such elementary thinking now, because we know everybody's body does something different, and we can't always control it. So science needs to accommodate for that, and science really needs to correct that. Just because there's a lot of DNA, this transfer trace, I'm not talking about the blood, sweat, slime, and semen, that's all for something else. In regard to the trace transfer DNA, is a very important fundamental principle that it needs to be ingrained everywhere, that DNA is changed. So just because there's a lot of someone's DNA doesn't mean they directly touched it or they were touching it during the time in question. All right. She also opines that the DNA found in a location that suggests it would persist for a long time because it was protected. I question that too, because it was encased in a copper environment. At least 3 sides. If the snap was snapped, it would be closed on 4 sides. But I don't know. It's not like it's on brass and it's on open air, because the female and the male part on the inner side, I do believe, is copper. I think it's only the actual snap that has that paint coating. But even with that paint coating, they make it with the same properties that copper has, that antimicrobial, where it kills germs. In effect, it will kill trace DNA as well. And, it's basically what you're killing when you use antibacterial stuff. You're killing the bad DNA so you don't get a cold. You don't get the flu. And so, yeah, and that's what copper does. The same thing as antibacterial. So I'm a little confused about how she would say it could persist for a long time in that location, but it could. It could. I don't know. All right, we're getting to the last part here where it says, given Dr. Ballard's anticipated testimony, Miss Nola's rebuttal is proper. She will discuss the process of primary and secondary transfer, the variables affecting transfer and persistence, and why she is of the opinion that the DNA on the knife sheath was more likely the result of direct transfer. Of course, here's a caveat. Of course, if Dr. Ballard limits her testimony on the stand, the court can reconsider the scope of Miss Nolan's rebuttal. That is the most questioning sentence I have in here, in this entire paper. Of course, if Dr. Ballard limits her testimony on the stand, the court can reconsider the scope of Miss Nola's rebuttal. Now, in the same context, when the defense said that they weren't going to have their expert talk about IgG, and so then Middleman doesn't have to talk, and for whatever reason, now the state may not actually be able to talk about where the tip actually came from. Is this another one of those scenarios where if the defense's expert doesn't talk about transfer, or what is it they're saying here? Because is it that straightforward that if an expert doesn't testify to certain things, then the opposing side's expert can't testify to those things that aren't argued? I'm curious about that. Get back to me if you know about that. Actually, let me double check, because I did put a question out on Twitter. I just don't know. Okay. All right. So my answer was, if you guys have a better one, let me know. It just depends on the scope. This still doesn't answer my question. I'll have to inquire further about that, but thank you for whoever answered that. I'll have to read it again. But the answer I got was scope, which makes me feel like that could be strategic, and the way that it was strategic when the defense said that they weren't going to have that those expert people talk about the IgG. So in this case, I don't know if that's the right thing to do or not. But Hitler put it in there, and I think this is still very puzzling to me. I am not really sure what this means. This could mean a lot of things, and this is what I mean about reading in between the lines. Something is here. I don't know what it is, but something is here. Okay, the last sentence here, it says, however, based on Dr. Ballard's report, Ms. Nolan's anticipated rebuttal is appropriate. Order, based on foregoing defendant's motion limine, Riley Nolan and reference to touch and contact DNA is granted in part and denied in part. Hello, welcome, Truth and Justice Anna D, and hello, Excited Utterance. Good to see you both. And this is another thing here. Right at the right at the end, we're getting some bombs here. This is the second one where it says it's granted in part and denied in part. And I know that it's my feeling that that's going to get looked over. And I know that like people have thought that the argument that the Vika had while she was in court didn't go so well. To the onlooker, I can understand why it might look like that, but this was actually a win for the defense. It was the win in it the entire time. And I know he did grant it in part, but now the two sides have to come together and they have to decide what word they're going to use, because this is incredible that Hippler did this. He says, in this limitation, the limitation includes the terms touch DNA and contact DNA, as was requested in the motion. In addition, based on Ms. Nolan's concern over the trace DNA, the court will advise against the use of that as well. And when you're making an argument that goes against the legal system and goes against, the public perception of what DNA is, it is almost impossible. It is an uphill battle. So Bicca Barlow and Massa just laying the foundation for this, and it gets this type of response. This is a win. Not only is it a win for Brian Koberger, it's a win for the legal system. It's a win for fairness. It's a win for understanding science a little bit more. It's a win for anybody who may or may not be wrongfully convicted in the future. Because when you're laying foundational arguments like this, and especially arguments, they're still arguing something that is not quite here yet. And that is very difficult to do. So not only are they arguing things that the legal system doesn't quite translate, they're arguing something that isn't here yet. That is incredibly hard to do, and they got their motion granted. And I don't think they even expected to get everything that they were. I don't think the intention was to get everything granted. That would be great, but this is a huge win. And especially if that's going to take that story away from the jury, which is what we want for fair trials. That is what we want for our amazing judicial system. We do not want the state to be able to tell a full story with 2 words, touch DNA. And they're not going to be able to do that. And if they do that, then the opposing party can get up and cross-examine the witness again, and to flesh out that. I think Hippler is going to give a little leeway there for them to flesh out what touch DNA actually means. So I think if it happens, it might, because usually, there's the direct, and then there's a cross, and there's a rebuttal. I think this is going to come in addition. If it happens, whatever team is going to be able to go again and have a little leeway to, really flesh out what this touch DNA actually means. So this is a game changer. And even if this does happen, even if somebody does slip, I only see it benefiting the defense. Because to really get in there and to be able to make it clear that touch DNA is not what we thought it was, and to be able, to be a skilled attorney, to just ask questions to get the expert to kind of, to generate that type of response is also very difficult to do. But I think that Bicca is very skilled, and she will be able to do that if anybody slips. And this is an overall win. And, I don't want to understate that, because I have this feeling people are going to be like, oh, they lost it. The defense loses everything. And, my thoughts on Hippler is the majority of this, I think he's fair. As much as I don't really want to say that, I think he is. He used the legal framework that he is allowed to use, the legal framework that he has to work in every day, and he looked at it. He examined it. He explained it. And within his limitations, he explained it very well. He explained both sides. And then he's just like, I would advise not to use these words. It's like, what word do you use? You can't use touch DNA. You can't use contact DNA. You can't use trace DNA. What word do you use? I know what word. I know what word. Are we ready? Are we ready? We're gonna use
Transfer DNA doesn't need anybody. Dips out quick like a ghost in the lobby. It moves, it shifts, it disappears, gets caught in the air. Just a breath, just a glance, just passing by. Never asks, never waits, always on the fly. Moves like whispers, light is air, everywhere but no nobody's there. Transfer DNA, a master shatter, a disguise in plain sight, wearing your face, but it can't say how or even when. Your own DNA, sabotaged and framed, doesn't eat.
Can you hear me, guys? It's gonna be transfer. It's totally gonna be transfer. And this is exactly what the defense wanted. And not only is it what they wanted, it's even better, I think. Excited utterance says he asked Grok. Daniel Sun, oh, it's so good to see you. Daniel Sun has some great videos if you haven't seen it. Hello. What did? Oh, hello. Are you saying Hitler asked Grok? Oh my god, that's so funny. Is that what you're saying? That's kind of funny. Transfer. It's gonna be transfer DNA, guys. Which is better than touch DNA because it doesn't have that much weight on a jury. And I believe that only benefits the defense. And if anybody does use the word touch, the defense gets to go at it. They get to go and explain their heart outs about what touch DNA is and how it may not be relevant in this particular case. And I know if there's anybody on the jury like me, I would appreciate that information. I would be like, oh, like I didn't know that information before. I'm glad I know now. Well, if this is what actual transfer DNA is, and if this is what it isn't, I appreciate that information, and I don't want to apply it to the case. You know, and of course, there's going to be people who already know about the nature of transfer DNA, and then of course, there's going to be people who are just like DNA is DNA. But I do think this makes a huge difference, and without this type of ruling, it's not as favorable. So this is a win. And I want to show you, speaking of Grok, maybe I can ask Grok. I was asking Chat GPT earlier. About what kind of jury instructions have there been in other cases regarding touch DNA. And they were all kind of boring, if you can imagine. That's why I feel like if it happens, it's just going to be a backup for. It's just going to be a backup because it may not happen. Nobody may slip, but I think they're going to have this on the ready. Let's see, this is the first question I popped in there. Ooh. I dropped my phone. Hold on. Okay. Want me to put in Grok? Grok might be good. Let's see what kind of answers he gives me because I asked Chat GPT before. All right. Here we go. You see, I'm on Grok, and we're going to ask them about jury instructions. Okay. let's see, before I put what court cases have had jury instructions that touch is not DNA transfer is direct or indirect. All right, let's see what Grok says, because I already asked ChatGPT, see if he has anything else to say. Oh, he gives me different stuff. Oh, here it is. Wait, no. That's a different case. This one's from the UK. The instruction was the case underscores the complexity of touch DNA interpretation. The defense's argument that DNA could have been transferred innocently suggests that the jury was likely instructed to consider indirect transfer possibilities. While exact instructions are not documented, the acquittal implies the jury was cautioned against over-relying on DNA evidence. Interesting. Even though this is the UK, it says potential instruction implication. A possible instruction could be DNA evidence does not prove guilt. You should consider whether the DNA could have been deposited through other means than direct contact, such as secondary transfer, and evaluate all the evidence in context. So that is a UK case. On the case details, David Butler was arrested in 2005, the murder of Anne-Marie Foy, based on a partial DNA match on her fingernail clippings and cardigan buttons. Butler, who had flaky skin due to a medical condition, argued that his DNA could have been transferred indirectly, for example, via coins handled by Foy. The defense emphasized that DNA presence does not prove contact, and Butler was acquitted after 8 months on remand. Okay. All right, well, let's read this Lucas Anderson case, even though I know a lot of you already know about him. So here's Lucas Anderson. This happened in California in 2012. Case details. Lucas Anderson was charged with murder after his DNA was found under the victim's fingernails. Anderson had been in a hospital detox unit at the time of the crime, and it was later determined that paramedics who treated him also handled the victim, likely transferring his DNA via shared equipment, for example, a pulse oximeter. The charges were dropped after his alibi was confirmed. Relevance to jury instructions. While specific jury instructions from this case are not publicly available, as it did not go to trial, the case highlights the risks of secondary transfer. It spurred discussions in forensic science about the need to educate juries on DNA transfer mechanisms. Court in similar cases may instruct juries to consider alternative explanations for DNA presence, such as indirect transfer, and to weigh DNA evidence alongside other case facts. There it is, the linking evidence. If there were other pieces of evidence that pointed to Brian Koberger being at the scene, that DNA would hold more weight, but we don't have that. Even if they have a car that they say is going in a direction, that still doesn't place Brian at the scene of the crime, and even that is not linking evidence, even if they have a nondescript video of a car how many miles away from the house. All right, so potential instruction implication. A court might instruct the presence of DNA does not necessarily mean the defendant touched the victim or was present at the time of the crime. You must consider whether the DNA could have been transferred indirectly through another person or object. Yeah, and I think a lot of times when people talk about DNA and DNA transfer and touch DNA, they forget another person can transfer your DNA. It doesn't have to be like, oh, it was transferred by an object. No, another person can do it. Just like in Anderson's case. The paramedic did it by accident, by the nature. All right, Amanda Knox. I know if you guys are true crime fans, I know most of you out there are. We know Amanda Knox. This one happened in 2007 to 2015. Case details: Amanda Knox and her boyfriend were convicted of murdering Knox's roommate, partly based on touch DNA found on a knife. The DNA was later questioned due to potential contamination and the possibility of secondary transfer. In 2015, Italy Supreme Court acquitted Knox, citing issues with evidence handling the misunderstanding of transfer DNA. Relevance to jury instructions. The case did not involve U.S. courts, so U.S.-style jury instructions were not applicable. However, the acquittal reflects the judicial recognition that touch DNA's limitations, including indirect transfer, must be communicated to fact finders. In U.S. courts, similar cases might prompt instructions to prevent juries from assuming DNA evidence is conclusive. Potential instruction implication. An instruction might state, you must not assume that DNA on an object proves the defendant touched it. DNA can be transferred indirectly. You should consider the possibility of contamination or alternative explanations. I don't know if the state's going to agree to that one, but that one's better. All right, we have R.B. Grayston in Canada, 2016. Oh gosh, look what's next. I wonder what they say about that. Okay, case details. In the Canadian case, the court noted that DNA evidence on objects is powerful evidence of contact, but emphasized that connecting the accused to the crime depends on other evidence establishing contact at the relevant time and place. Relevance to jury instructions. Canadian courts have been cautious about DNA evidence in circumstantial cases, often instructing juries to consider the broader context. While specific instructions are not quoted, the ruling suggests juries were advised to avoid over-relying on DNA without corroborating evidence, implicitly acknowledging transfer issues. Potential instruction implication. A jury might be told DNA evidence must be evaluated alongside other evidence. The presence of DNA does not necessarily mean the defendant was involved in the crime, as DNA can be transferred in many ways unrelated to the offense. Oh my God, it came out with Brian Koberger. Can you believe it? All right, here we go. What does Grok have to say about Brian Koberger? This is Brian Koberger case, Idaho, ongoing as of 2025. Case details. In the Brian Koberger case, the motion in limine regarding references to touch and contact DNA was filed, as noted in a post on X on April 18, 2025. While the case is ongoing and specific jury instructions are not yet available, the motion suggests that the defense is challenging the interpretation of touch DNA evidence, likely raising issues of direct versus indirect transfer. Relevance to jury instruction. The motion indicates that the court may need to address how touch DNA is presented to the jury, potentially leading to instructions clarifying its limitations. Given the case's high profile, any jury instruction would likely emphasize the uncertainty of DNA transfer mechanisms to prevent prejudice. Potential instruction implication. The court might instruct You might consider that touch DNA may not indicate direct contact with the item. DNA can be transferred indirectly, and you should weigh this evidence carefully with all the other evidence in the case. It's a little weak, but this is what I'm talking about. It's already started. Becca Barlow has laid a foundation with her argument, and it's already been picked up. It's already influencing our sphere. And so that's why I think everything that Brian's defense team has done with the DNA that they have, they are arguing arguments that aren't here yet, and they're doing beautifully. And I can't believe they even picked up Brian Koberger when we asked, what are other cases that dealt with touch DNA and what a jury instruction might look like. So Grok answered it a little bit different than ChatGPT, but we can also put that in ChatGPT as well. Oh wait, there's a little bit more here. It says general trends and jury instructions for touch DNA. While no case explicitly documents jury instructions with the exact phrasing you requested, courts in the U.S. and other jurisdictions have increasingly acknowledged the limitations of touch DNA through rulings, expert testimony, and jury instructions. Key trends include caution against reliance. Courts often instruct juries that DNA evidence, particularly trace or touch DNA, is not conclusive proof of guilt and must be considered in context with other evidence. For example, the American Bar Association has argued caution in interpreting DNA statistics to avoid misleading juries. And Becca Barlow, look into that. Because if the American Bar Association has urged caution, you've got people here in the U.S. who are urging too. Because I think one of the criticisms of the human factors report was that they weren't all here from the U.S. and that these things were recommendations that aren't here in the U.S. courts yet. But if the American Bar Association is commenting on misinterpreting statistics, that could be fruitful. I don't know. Acknowledged of transfer issues. Judicial instructions may highlight that DNA can be transferred indirectly, as seen in cases like Butler and Anderson. Butler, we just read about that, where secondary transfer was a plausible explanation. Judicial standards. In the U.S., courts apply standards like the general acceptance test or sound methodology standard to ensure DNA evidence is reliable. Judges may instruct juries on factors affecting DNA analysis, such as the possibility of contamination or transfer. Case-specific guidance. Instructions are tailored to the case facts. For instance, if the defense argues secondary transfer, the court may direct the jury to consider alternative scenarios for the deposition. Okay. Sample jury instruction based on current practice. Based on the principles observed in the above cases and forensic literature, a hypothetical jury instruction addressing touch DNA and transfer issues might read: you have heard evidence about DNA found at the crime scene, sometimes referred to as touch DNA. The presence of a person's DNA on an object or at a scene does not necessarily mean they touched the object or were present during the crime. DNA can be transferred directly through contact or indirectly through another person or object. And it is not always possible to determine how or when the DNA was deposited. You must consider all possible explanations for the presence of DNA, including indirect transfer, and evaluate this evidence in context of all other evidence presented in the case. DNA evidence alone is not sufficient to prove guilt beyond a reasonable doubt unless supported by other credible evidence. That one's not terrible. What do you guys think of Grok's suggestion here about what a jury instruction could be? I think this is the best one out of all of the ones that they were suggesting. That was pretty good. You guys like this one? It says this instruction aligns with the scientific consensus that touch DNA's source and transfer mechanisms cannot be definitively determined and reflects judicial efforts to mitigate juror misconceptions about DNA's reliability. Why exact instructions are hard to find? Limited public records. Jury instructions are often case-specific and not always published unless part of a high-profile appeal or reported decision. Many cases settle or do not reach appellate courts, leaving instructions undocumented. Evolving science. Here we go. The understanding of touch DNA transfer has developed rapidly since early 2000s, and courts are still adapting. Instructions may vary by jurisdiction and judge, reflecting local standards and case facts. Confidentiality ongoing cases. In cases like Kohberger's, oh my God, it's referencing Kohberger again. In cases like Kohberger's, ongoing proceedings may limit public access to motions or instructions until the trial concludes. Interesting. Recommendations for finding specific instructions. To locate cases with precise jury instructions matching your query, consider the following. Legal databases. Search Westlaw, Nexus, LexisNexis, or Pacer for U.S. cases involving touch DNA, focusing on motions in limine or appellate rulings discussing jury instructions. Keywords like touch DNA, DNA transfer, and jury instruction may yield results. Forensic science journals. Articles in journals like Forensic Science, International Genetics may reference cases where DNA transfer was contested, potentially citing instructions. I do believe we asked Crack a generic question about, touch DNA jury instructions, and it referenced Kohberger like two or three times? Well, 3 times now. So I do believe that Kohberger's case will be written about in scientific journals going forward. This is a pivotal case, whether people, realize it or not. I can see it, but that's just me. I'm just a little nobody over here who is fascinated by science. All right, so court transcripts. Request transcripts from high-profile cases, for example, Kohberger, through court clerks, through access, although access may be restricted until trials conclude. Defense attorney networks. Contact organizations like the National Association of Criminal Defense Lawyers, the NACDL, for insights into cases where DNA transfer was a defense strategy, as they may track relevant instructions. Conclusion. No publicly available case explicitly documents jury instructions stating that touch DNA is not what it once thought to be, and that it is not possible to determine whether DNA transfer is direct or indirect. However, cases like Lucas Anderson, David Butler, Amanda Knox, and R.V. Grayston demonstrate that courts are increasingly aware of touch DNA's limitations, particularly regarding indirect transfer. Jury instructions in such cases likely caution against over-relying on DNA evidence and emphasize the possibility of indirect transfer, as seen in general judicial trends. The ongoing Brian Kohberger case may provide further clarity if jury instructions are made public. For precise instructions, legal databases or court records are the best resources, though access may be limited for recent or ongoing cases. What is that, 4 or 5 times it referenced Kohberger? We didn't even ask it about Kohberger. Oh my gosh, that's so crazy. That's cool. Grok gave us a very detailed answer. ChatGPT wasn't. So I wonder if there's a way I can pull these up, because I took a pictures of what I asked it earlier. Okay. Well, I really like Grok's suggestions. Let me read the suggestion one more time before I bring up what ChatGPT said. Here's what Grok's suggestion. You have heard evidence about DNA found at a crime scene, sometimes referred to as touch DNA. The presence of a person's DNA on an object or at a scene does not necessarily mean they touched the object or were present during the crime. DNA can be transferred directly through contact or indirectly through another person or object, and it is not always possible to determine how or when DNA was deposited. You must consider all possible explanations for the presence of DNA, including indirect transfer, and evaluate this evidence in context of all other evidence presented in the case. DNA evidence alone is not sufficient to prove guilt beyond a reasonable doubt unless supported by other credible evidence. I don't know about you guys, but let me know. This idea that DNA can transfer through another person, I don't know, I'm really gravitating towards that. I wonder if that's easy to understand. All right, now, that was really cool. Maybe I just need to bring ChatGPT up. And we'll ask ChatGPT the same thing. All right. Okay, good. You can see it. Hi, Truth and Justice with Crime of the Entity. Well, right now I'm just going over the DNA. I haven't decided if I'm going over all the other documents yet. I haven't been able to read them, but I definitely wanted to get this out because it's my favorite. Okay. And the question I asked is the same one I asked Grok. It says, what cases had jury instructions the touch DNA is not what it was once thought to be, and it's not possible to determine with DNA transfer if it's direct or indirect? And ChatGPT says, the issue you're referring to seems to involve the evolving understanding of touch DNA and challenges in interpreting its presence in forensic cases. DNA analysis, particularly related to touch DNA, has become more complex over time as the science of forensic genetics has advanced. Context of touch DNA and jury instructions. Touch DNA refers to the genetic material left behind by someone simply touching an object or a surface. This DNA could be deposited through sweat, skin cells, or other biological materials left behind after contact. While the idea was once thought to provide concrete evidence of someone's presence at a crime scene, the science has now shown that it is not always definitive and can be subject to contamination, transfer, or result of indirect contact. Here are some legal cases and judicial developments related to touch DNA and its interpretation in courtrooms, which might have influenced jury instructions. All right, who do we have here? First, we have People versus McDonald, California, 2014. In this case, touch DNA was used as evidence to implicate the defendant. The California Court of Appeal considered how DNA was transferred to the crime scene and what it could actually prove. The court acknowledged that while DNA might be present, it does not conclusively prove that the individual directly interacted with the item. the victim's clothing in a meaningful way. The case led to a greater understanding of how DNA evidence could be less definitive than once believed. Key takeaways. Jury instructions in this case involving touch DNA have become more nuanced, making it clear that the presence of DNA does not automatically imply direct contact or active involvement in the crime. The presence of DNA can be circumstantial, not direct proof of guilt. 2. State v. Sinclair, 2017, Ohio. In this case, the defense argued that the presence of touch DNA on an object didn't necessarily indicate that the defendant had touched it directly. Instead, DNA could be transferred indirectly or left behind without active engagement, such as through a handshake or brief interaction. That's it, just brief interaction. You don't have to touch anything. The court allowed expert testimony to explain how DNA transfer could happen without direct contact, and jury instructions reflected the limitations of that evidence. Key takeaways. Expert testimony regarding the potential for indirect DNA transfer was critical in framing the evidence. Jury instructions had to clarify that touch DNA evidence alone should not be viewed as proof of direct involvement, especially given the uncertainty about how DNA was transferred. 3. People versus Middleton, 2014, Illinois. The case involved the prosecution's reliance on touch DNA recovered from an object linked to a crime. The defense argued that the DNA could have been transferred indirectly or from prior contact. The court noted that DNA analysis does not distinguish between direct and indirect transfer, meaning the presence of DNA doesn't automatically mean the defendant had direct contact. Key takeaways. The jury was given instructions that highlight the limitations of DNA evidence and the possibility of indirect transfer. The scientific uncertainty about mechanism of DNA transfer was highlighted, and the jury was advised not to give undue weight to the presence of DNA. 4. State v. Montague, 2008, Ohio. In this case, touch DNA was recovered from a piece of evidence, and experts testified about the potential of DNA transfer via indirect means, including secondary transfer. For example, DNA transferred through the victim's clothing or other objects that the defendant may have never directly touched. The court ruled that the presence of DNA doesn't equate to direct involvement in the crime, and this was reflected in the jury's instructions. Oh, this is a good phrase. I don't know if the state will go with that, but the presence of DNA doesn't equate to direct involvement in the crime. I think that's good. That's good for jury instruction. All right, key takeaways. The jury instructions emphasize the possibility of indirect DNA transfer. The jury was cautioned against assuming that the presence of DNA directly linked the defendant to the crime scene or act. All right. Judicial trends and jury instructions. In general, the trend in jury rulings and jury instructions regarding touch DNA is the presence of DNA should not be seen as definitive evidence of direct contact. Court rulings and experts in these cases have increasingly emphasized that DNA could be transferred indirectly, making it difficult to determine the exact nature of the contact. Legal developments. In light of these cases, judicial awareness has grown about how DNA analysis should be presented in court. Experts now commonly explain that touch DNA doesn't provide absolute proof of direct involvement. Indirect transfer is a known phenomenon, making it impossible to conclusively determine whether DNA found at a crime scene was transferred directly or indirectly. DNA could come from multiple sources and does not automatically mean the person was physically present at the crime scene. So far, I like the presence of DNA does not equate to direct involvement in the crime. And DNA could come from multiple sources and does not automatically mean the person was physically present at the crime scene. I do think that the direction should be a little less scientific. And I think those two, I don't know. Let me know if those two things stand out for you. Because those were the two that stood out to me the best. Okay, so conclusion. While there's no specific one case where jury instructions categorically state that touch DNA is not what it was once thought to be, the cases above reflect the changing legal landscape. Judges are increasingly cautious in allowing DNA evidence to be interpreted too broadly, especially when it comes to touch DNA. Oh, when I put my feelers out on Twitter, and thank you for my friends who answered my questions, I love that, they talked about scope. And here they're talking about judges are increasingly cautious in allowing DNA evidence to be interpreted too broadly. I feel like there's a connection there, and I'm not quite sure how they fit yet. So too broadly and narrow scope. So Hippler did leave the door open for the defense, I guess, to narrow their expert's testimony. And if they narrow their expert's testimony, he could reconsider what Riley Nolan has to say. I wonder if that's an invitation or what that means there. If anybody has any ideas, please comment below or in the chat. Okay. So judges are increasingly cautious in allowing DNA evidence to be interpreted too broadly, especially when it comes to touch DNA. Jury instructions now often contain caveats regarding the uncertainty of DNA transfer and its limitations as evidence of guilt or involvement. If you're interested in a specific jurisdiction or case, I can help you narrow it down further. Ooh, can we just put in Idaho? And bring up things other than Cobra. Okay. So I put in Idaho. This is what I say about Idaho. In Idaho, as with many other states, the use of touch DNA as evidence has been evolving, particularly when it comes to understanding its limitations. Side note, I really like this term evolving. Becca Barlow used it. I think it was her first sentence, one of her first sentences to Hippler. I thought that was beautiful. Evolving. That to me says a story of the DNA is evolving. I don't know. Let me know. I really like how we're seeing a common thread here as Grok and ChatGPT are both using the words evolving, and Becca Barlow as well. So DNA evidence has been evolving, particularly when it comes to understanding its limitations. When there may not be a singular landmark case specifically focused on jury instructions related to touch DNA in Idaho, there are general trends in DNA evidence law that impacts how courts handle such evidence, and similar principles would apply in Idaho courts. Idaho's approach to touch DNA evidence. Idaho courts, like many other states, follow general principles regarding forensic evidence that are rooted in the idea that DNA evidence should be treated with caution and not automatically accepted as absolute proof of guilt. This approach stems from the realization that touch DNA is not as infallible as it once seemed, particularly in cases where it may be transferred indirectly. In some cases, DNA can be transferred from one person to another without direct contact. I like that too. I don't know if you could put that in the jury instruction. DNA can be transferred from one person to another without direct contact. That tells a story to me too. And it says, there's people involved. Anyway, such as though secondary transfer, for example, though a shared surface or object, or through a shared surface or object. Here's a breakdown of how Idaho might treat touch DNA evidence in court and what types of jury instructions could be used based on general legal trends in the state. Ooh, this is fun. This is all about Idaho. Okay. Key elements in Idaho related to DNA evidence and jury instructions. 1. Scientific understanding of DNA transfer. In Idaho, the Daubert standard is used. I don't know about that. I've read that Idaho does its own thing, and even Hitler said that. Anyway, maybe they use something similar, which is what there were 702. Anyway, so in Idaho, they probably don't use Dauber for determining the admissibility of expert testimony, which includes forensic DNA analysis. Experts must be able to testify about the accuracy and reliability of the techniques used to collect and analyze DNA evidence. This includes touch DNA, which might not always offer a clear understanding of how DNA was transferred. Judges are likely to require expert testimony about the limitations of DNA evidence, including indirect or secondary transfer. For instance, DNA found in an object does not necessarily indicate direct contact by the defendant, but could suggest that the defendant came into contact with the item indirectly, such as through touching another object that the victim had the victim's DNA on. Oh, the object that had the victim's DNA on it. Oh, so I had a thought, but it just. Oh, right. So I want to ask a question about that later. Okay. Jury instructions in a DNA case. In cases involving touch DNA, jurors are often instructed to consider that DNA may be transferred in various ways, and presence alone does not equate to direct involvement in the crime. For instance, a jury might be told that DNA evidence is not proof of direct involvement in the crime. It could be transferred through indirect means. Yeah. The presence of DNA on an object does not necessarily mean the person touched the object in question. DNA can be transferred through the secondary contact, such as from another person or item. So if I were going to do these jury instructions, I wouldn't use the word touched. So I do really like how this first suggestion under this first indented bullet, DNA evidence is not proof of direct involvement in the crime. It could be transferred through indirect means. Yeah, so don't use that word touched in your jury instruction. In my opinion. The presence of DNA in an object does not necessarily mean the person touched the object in question. DNA could be transferred through secondary contact, such as from another person or item. These types of instructions help prevent jurors from mistakenly assuming that the presence of touch DNA automatically establishes guilt or presence. I'm adding word presence. 3. Indirect DNA transfer and secondary transfer. As in many other states, Idaho courts recognize that the potential for secondary DNA transfer, which is when DNA is transferred indirectly from one object or person to another. In this case, experts may be called to explain how DNA can be transferred through clothing, items, or even other people without the defendant's direct involvement with the crime. So DNA can be transferred through items and other people without the defendant's direct involvement. That sounds good too. That sounds, what do you think? That sounds like good and to the point. All right, next bullet. Courts in Idaho would likely allow expert witnesses to explain that touch DNA does not conclusively establish whether contact was direct or indirect. 4. Cases involving DNA in Idaho. While there might be a specific well-known case in Idaho that focuses solely on touch DNA and jury instructions, there have been cases in the past where DNA evidence has been challenged for its reliability in criminal trials. In these instances, courts have frequently allowed DNA evidence to be challenged in terms of its interpretation. For example, how it was transferred and accuracy. Whether contamination or secondary transfer could be an issue. For example, in State v. Garcia, 2017, the Idaho Supreme Court considered the reliability of DNA evidence used in a case. While the case was not focused specifically on touch DNA, it highlights the type of analysis that might be done in Idaho courts for any forensic evidence, including DNA. Expert testimony on how DNA was collected, how it might have been transferred, and what it means for the case would have been critical in this kind of analysis. So the AI is picked up from however it scans information. So does it read court stuff? Because if it read and analyze it a little bit, and it's relaying information that it would have been helpful in what it's reviewed if the testimony commented on how it was collected, how it might be transferred, and what it means for the case would have been critical. So maybe the cases that it analyzed to put together this information was lacking that. I don't know how AI works, but I don't know. That just struck me by reading that. Specific case and examples in Idaho. While Idaho may not have a landmark case specifically addressing touch DNA and its limitations, in the same way, other states have developed jurisprudence on the topic. Idaho v. Bryant, 2011, could provide an example of how courts in the state treat forensic evidence broadly. Okay. In Bryant, DNA evidence played a role in the case and is noted that expert testimony was essential in explaining the mechanics of DNA transfer and how touch DNA may not necessarily be the result of direct contact. I wonder why it was essential. Jury instructions in such cases often stress the limits of DNA evidence and make it clear that DNA, while powerful, cannot provide conclusive proof of a person's actions without supporting context. That linking evidence is this nagging thing that I keep hearing, you need that in order for this transfer DNA to be relevant. Otherwise it's scary that, anyway. How Idaho courts might handle jury instructions for touch DNA. Cautionary instructions. Judges in Idaho are likely to issue cautionary instructions to the jury, advising that DNA evidence should not be viewed in isolation. Don't view it myopically. These instructions often highlight the possibility that DNA could have been transferred indirectly and remind jurors not to assume that the presence of DNA conclusively proves guilt. For example, an instruction could state, one sec. I love this new mic, guys. I don't know if you can tell the difference. I can automatically see and feel this mic from Shure. From what I was reading, Shure is kind of like Rode. They're almost studio quality. All right, so where were we? For example, an instruction could state the presence of DNA evidence does not automatically establish that the person whose DNA was found directly interacted with the object in question. DNA may have been transferred indirectly or from another person. I like from another person for some reason. It just makes things more personable. I can understand that, people are moving. People are walking, and I can see how a person could have the DNA travel instead of oh yeah, it just transfers. I don't know. I think it's descriptive. I don't know if you guys you get what I'm saying. All right. Expert testimony. A court might emphasize that DNA experts should explain how touch DNA could result from indirect contact or secondary transfer. The jury should consider whether there are other plausible explanations for the presence of DNA at a crime scene. I'm just thinking, because it's a movable object, so that adds a layer of indirectness, because it's not like Brian's DNA was found like on the crime scene or in it. It was on an object that we don't know what time that object arrived, and we don't know what time Brian's DNA was actually put on there. So I wonder if the time of the crime has anything to do with it. Because if this cell phone data is what the defense says it is, then obviously the DNA or the object may not have gotten there at the time the state is saying. There's a lot riding on the cell phone data and timeline, I think. I think the timeline somehow is like hidden because the DNA and the cell phone data have taken like the spotlight. Well, cell phone data especially, but they keep driving a wedge in this text messages. The whole thing falls apart. Anyway, maybe we'll have another live on that. I just like keep going back to that. Conclusion. While there's no single Idaho case that specifically addresses touch DNA with the same level of detail as some other states, Idaho courts follow general principles of forensic science and expert testimony to explain DNA transfer. Jury instructions in Idaho cases involving touch DNA would likely mirror those found in other cases focusing on the possibility of indirect or secondary transfer, and cautioning jurors not to assume the presence of DNA equates direct involvement in the crime. I like that. It's the wording for that right there. All right. It says at the last part, ChatGPT says, if you're looking for a more specific case or additional legal resources from Idaho, it might be helpful to look at specific criminal defense cases or appeals that may involve DNA. Ooh. All right. I do want to see the appeal stuff, but I also, okay. So I do want to do, I want to put this over here for now. Okay. And then what I want to do is I want to look at appeals that involve, I want to put in touch. And then we'll do in Idaho. Appeals that involve touch DNA evidence in Idaho. It says, while Idaho has had numerous criminal cases involving DNA evidence, appeals specifically challenging touch DNA and its interpretation are less commonly discussed in public law or in the public case law. However, as touch DNA technology has its limitations have become more widely known in recent years, The potential for its misuse or misinterpretation in criminal cases has increased, leading to the possible challenges on appeal in cases involving such evidence. Although I could find specific Idaho appeals directly centered on touch DNA. Although I couldn't find specific Idaho appeals directly centered on touch DNA, the general framework for challenging forensic DNA evidence, like DNA, is often rooted in issues of evidence admissibility. Oh, Hippler said admissibility a few times. Okay. Expert testimony and misleading jury instructions. Cases involving DNA can raise issues related to the probative value of touch DNA, especially when arguing that it doesn't necessarily indicate direct contact or involvement. Here's a look at how DNA evidence, including touch DNA, might be challenged on appeal in Idaho, and some examples of cases involving DNA evidence that touch on challenges of its interpretation. State v. Baez, Idaho Court of Appeals, 2019. Although not specifically about touch DNA, the case involved the use of DNA evidence and discussed how courts treat DNA in criminal cases. The defendant in Baez was convicted based on DNA evidence, and the appeal focused on issues related to the admissibility of forensic evidence, including whether the evidence was properly explained to the jury and the implications of contamination. Issue on appeal. The appeal argued that DNA evidence was improperly handled and that the testimony on its interpretation was misleading. There you go. Oh, God. So if this does get to appeals, by that time, there will be more like foundation of laying this DNA argument. And they might have a case there if, for whatever reason, Riley Nolan does proffer her inappropriate personal opinion. That could be an issue on appeal. I don't know. I guess the state doesn't care about it. All right, relevance to touch DNA. While Baez doesn't specifically deal with touch DNA, it reflects on the type of procedural concerns that would be relevant to cases involving DNA evidence, particularly touch DNA. The handling of forensic evidence and proper jury instruction about the limitation of DNA evidence that would be central to any case involving touch DNA. That also makes me think, I don't know, Hippler mentioned admissibility a few times, and he also mentioned if Dr. Ballard, I think, would limit her testimony, that he would reconsider Riley Nolan's expert testimony. And I'm just thinking, I don't know, sometimes I think he does give little hints, and I'm not sure if that's a little hint, whether he's trying to tell them to proffer an argument that has to do with procedural concerns. I don't know, that just popped in my head. I don't know, there's so many ways you can go about arguing this DNA. And just because the defense has started doing it like related to the science, it doesn't mean that they can't change it up and go a different direction. I think I'm going to think more on that to see if there's a connection there with is it a stronger argument to go with procedural concerns or methodologies, or is it stronger to just go in, head on with the science? Or is there a way to, use all those elements, procedural methodologies and the science? But I don't know, that this procedural concerns jumped out at me for whatever reason. All right, it says key takeaway. In appeals involving DNA evidence in Idaho. Wait, did I miss one? No. In appeals involving DNA evidence in Idaho, challenges often arise around how the evidence is handled and whether expert testimony adequately addresses the potential limitations and uncertainties of DNA transfer, including the possibility of secondary or indirect transfer, which is especially relevant for touch DNA cases. And that also reminds me, I could be wrong, but I seem to remember in we call it the secret transcript, where Anne is questioning Riley Nolan, and I think she said it was a him, was it her, or was it David Gammy? I think it was Riley Nolan, where Riley Nolan said something to the effect of, I would have to find out where she tested it. I would have to look back in the notes. And I think she was talking about whether the snap, the top part of the snap was swabbed. So on the stand, it sounded like Riley Nolan didn't quite know who or what was tested. So maybe that's another angle to go at this, because she was just like unsure. I feel like as a jury, like their expert didn't even know what they did. I don't know. Is that kind of stuff related to the procedural and methodologies? Because that's another angle of attack there as well. I don't know. I'm thinking out loud here. GPT's got me going. All right. Okay, key takeaway. In appeals involving DNA evidence in Idaho, challenges often arise around how the DNA evidence is handled and whether the expert adequately addressed the potential limitations and uncertainties of DNA transfer, including the possibility of secondary or indirect transfer, which is especially relevant for such DNA cases. 2. State versus Balikoff, Idaho Supreme Court, 2014. Although this case involved blood evidence rather than touch DNA, the appeal raised similar issues concerning the admissibility and reliability of forensic evidence. The defendant challenged methods used by forensic scientists to handle the test evidence. Oh, that reminds me. Misty Blue. Oh, she's gorgeous. I love her. She posted something on Twitter today, and it really made me think. And I told her what I was thinking, and it was, why didn't the police test the blood evidence found on the handrail and the glove outside? Because wouldn't it just bolster their case to test it to see if it matched the DNA on the knife sheath? So that is odd that they didn't test the blood, especially if they didn't know that it was the same DNA that they're finding on this knife sheath. That would have been stellar. If they had DNA on the knife sheath, they had DNA on the handrail and or the glove on the outside. That's the type of linking evidence that makes that transfer DNA more powerful. But they completely missed that opportunity. They just didn't even test the blood. That doesn't even make sense. Because the only reason why I feel like people wouldn't test the blood is because they already knew who it belonged to. So they didn't bother. So they knew it didn't belong to Brian. Otherwise, wouldn't they be like, we got to test it. We got to see if it's the same thing, It's just very odd. So, issue 1 appeal. The defense argued that the evidence was improperly analyzed or that the procedures used to collect the DNA were inadequate. Relevance to touch DNA. If touch DNA were introduced in such a case, similar arguments could be made about the possibility of contamination or misinterpretation of secondary transfer, especially if the DNA was recovered from a shared surface or indirectly transferred. Key takeaways. This case is a good example of how evidentiary challenges, such as improper handling or analysis of DNA, are a critical part of criminal appeals. These same principles could be applied to touch DNA, where concerns about contamination or improper interpretation are central. Number 3, State Telvin Lynn, Idaho Court of Appeals, 2018. In State v. Tevlin, the Idaho Court of Appeals considered issues related to DNA evidence presented during trial and how expert testimony could influence the jury's understanding of the evidence. The defendant argued that the jury was improperly instructed on how to interpret the DNA evidence. Issue on appeal, the defendant contended that the trial court's jury instructions were insufficient in explaining the limitations of DNA evidence and failed to account for the possibility of contamination or other factors that could explain the presence of DNA. Relevance to touch DNA. The Tevlin case mirrors what could happen in a case involving touch DNA. If touch DNA were introduced, the jury would need a clear instruction on the possibility of indirect transfer and the limitations of interpreting such evidence. Whoa, I just had an idea. Oh my gosh, guys. If this transfer DNA, obviously it's not as strong as blood, sweat, semen, or saliva. So you need a lot of context around it. You need to know how it fits in the case relevant facts. You need to know if there is connecting evidence. But if you're not even allowed to talk about the tip, you're not even allowed to talk about where this evidence came from or the identity that came from, I feel like that poses a big problem. It's like, how did you get the identity of this trace DNA? And isn't that extremely important with something like trace transfer DNA? Because if they had tested the blood, they would have known. They would have more case relevant facts. Anyway. Key takeaways. The clarity of jury instructions in cases involving DNA evidence, including touch DNA, is crucial. Courts must ensure that jurors are properly informed about the uncertainties and limitations of forensic evidence, especially in cases where the DNA could have been transferred indirectly. 4. State v. O'Leary, Idaho Supreme Court, 2009. This case, while not directly related to touch DNA, involved a challenge to the admissibility of DNA evidence. The defense raised concerns about the chain of custody and reliability of the DNA evidence presented at trial. Issue on appeal, the defense argued that the DNA evidence was not properly handled or that its chain of custody was broken, which led to questions about the integrity and whether the jury could reasonably rely on it. Relevance to touch DNA. For cases involving touch DNA, issues such as the chain of custody and whether the DNA evidence could have been contaminated or transferred indirectly are important factors that could be raised on appeal. Key takeaway. Challenges regarding the chain of custody are common in appeals involving DNA evidence. With touch DNA, where the possibility of secondary or indirect transfer is greater, issues around handling and interpreting the evidence would likely be points of appeal. General approach for appealing touch DNA evidence in Idaho. Oh, this is awesome. In Idaho, if touch DNA were used as evidence in a criminal case and an appeal were filed based on this evidence, the following arguments could be made. 1. Misinterpretation of the evidence, the defense could argue that the jury was misled into believing that the presence of DNA on the object necessarily implied that the defendant had directly interacted with it without considering the possibility of secondary or indirect transfer. 2. Inadequate jury instructions. A common basis for appeal would be that the jury instructions fail to properly explain the limitations and uncertainties of touch DNA as forensic evidence. The jury may need clearer guidance on how touch DNA can be transferred indirectly. 3. Expert testimony. An appeal could challenge the qualifications or the credibility of an expert testimony used to explain the DNA evidence. In the case of touch DNA, the defense may argue that expert did not sufficiently explain the potential for secondary transfer or contamination. 4. Chain of custody issues. If touch DNA was collected improperly, or if there were concerns about chain of custody, an appeal could argue that the evidence should have been excluded or given less weight. Conclusion. While there may not be a landmark appeal in Idaho specifically related to touch DNA evidence, cases involving DNA evidence generally address many of the same issues that would arise in touch DNA context. Appeals in Idaho typically focus on whether the DNA evidence was handled properly, whether expert testimony was reliable, and whether jury instructions adequately informed jurors of the limitations of DNA evidence, especially with regard to its potential for indirect transfer. If you're looking for more specific cases on further legal precedents, checking Idaho appellate court opinions or consulting with local criminal defense could yield more details. Legal precedents. I don't know if you guys could even see me. No, you can't even see me. Oh, I didn't plug that in. I don't have any lights. I don't. I mean, I do, but I have to get over and get the switch. Like kick me out. All right, so I think that was interesting to learn about how things work in Idaho in regard to like jury instruction, or how courts in general have dealt with touch DNA. And I can't believe we asked what was a Gruck, and he had referenced Koberger 4 or 5 times, and we didn't ask him about Koberger. Oh my gosh. All right. So I think this live is getting long enough. ChatGPT is like not responding, and I can't get my ring light right now. Anyway, thank you everybody in chat. Thank you everybody on the replay crew. And I hope you guys can hear me. I did impromptu unboxing earlier with this new mic. Hopefully there's no more sound issues. Thank you. Bye guys. Oh, thank you, Deviled Eyes. Thank you. Bye.
Ghost DNA, haunted by the past, echoes of whispers that never quite last. Unknown, but visible and missing bones, just out of reach, like flickering shadows. Like a glitch in the code, jump scares and double takes, but nothing is there, just traces of history caught in the air. Ghost DNA, living in present day, haunting the strands in a spectral array, only coded, but never erased. The ghosts in our bloodline resurrected their stories, like biohackers, throwing cheat codes, cracking genomes and shifting blueprints. Ghosts in the sequence, breaking the locks, tailor-made medicine and DNA edits. Just out of reach, like flickering shadows, like a glitch in the code, jump scares and double takes, but nothing is there, still haunting the helix, still caught in the air. Ghost DNA. Ghosts in our bloodline resurrected their stories. Frequencies whisper in cellular chains, stories encrypted in chemical veins. A ghost in the code, a switch in the key. Ghost DNA never fades away, lingering echoes, rewriting the way. Only coded, but never erased. Just out of reach, like flickering shadows, like a glitch in the code. Jump scares and double takes, but nothing is there. Just traces of history caught in the air. Ghost DNA, living in present day, haunting the strands in a spectral array. Only coded, but never erased. The ghosts in our bloodline resurrected their stories. Like biohackers, throwing cheat codes, cracking genomes and shifting blueprints. Ghosts in the sequence, breaking the locks, tailor-made medicine and DNA edits. Just out of reach, like flickering shadows, like a glitch in the code. Jump scares and double takes, but nothing is there. Still haunting the helix, still caught in the air. Ghost DNA, living in present day, haunting the strings in a spectral array. Only coded, but never erased. The ghosts in our bloodline resurrected their stories.